This High Court case, heard in 1990, considered the purposive approach to statutory interpretation. The purposive approach says that the court should always interpret statutes by looking to the purpose of the Parliament in passing the legislation. That purpose should be found by looking at materials such as the Minister's second reading speech. This can be trickier than it sounds. The Victorian Road Safety Act contained rules for police to administer breath tests for alcohol. If you look at those rules, it seemed like the Parliament was creating two different regimes. A regime based on immediate breath tests for drivers found merely driving their car, and a regime based on delayed testing for drivers who were involved in accidents. This would allow, for instance, the driver to be identified, or if the driver themselves required treatment, it might allow that treatment to proceed. Mills underwent delayed testing, but he had not been involved in an accident. He suggested that the police were using the power in a way that the Parliament never intended. On his argument, because he wasn't involved in an accident, he should have been tested immediately or not at all. The flip side was that if you took a literal approach, the provision didn't explicitly limit the delayed testing to circumstances where there had been an accident. Well, Mills lost his appeal 3 judges against 2. So even among 5 High Court judges, they remained split on what the Parliament had meant. How could this be so? Justice Dawson questioned whether there was such a thing as parliamentary intention at all. He said, "As everyone knows, the intention of Parliament is somewhat of a fiction. Individual members of Parliament or even the government do not necessarily mean the same thing by voting on a bill, or in some cases anything at all." He also found the speeches given in parliamentary debates were of limited value. He said, "The report of a speech of a member of Parliament other than that of the minister moving the second reading of the bill may often be unhelpful, and even a second reading speech may be of little relevance." The purposive approach is still our dominant approach to statutory interpretation, but it still rests on the fiction that the Parliament had a single intention which can be recognised and interpreted.